Hello, I'm Stuart Evans, and I'm a commercial litigation partner at BLM. We have been discussing internal investigations and the key considerations for businesses in the light of COVID-19. We have seen that many challenges arise when a business decides to undertake an internal investigation, and we have looked at what it should have in mind when seeking to pursue an investigation remotely. Today, I'm looking at the issue of privilege. This is the protective cloak of confidentiality that businesses can wrap around sensitive and private materials. The reason for privilege in investigations is that it's in the public interest for companies to be able to investigate allegations without losing the benefit of legal privilege. But it needs to be understood and carefully protected. The investigation team must therefore be wary of privilege, whether that relates to interview materials or other work product or communications. It is an area that will need lawyer involvement. There are two categories of privilege to consider. The first is litigation privilege. This covers communications between your business, your lawyer, and third parties, documents made by or on behalf of your business or your lawyer, such as interview or investigation notes, which are confidential and, importantly, made for the dominant purpose of litigation. Now, that litigation may be civil or criminal and must be pending, reasonably contemplated, or existing. For litigation privilege to apply, it is important to document from the start the purpose and scope of the internal investigation. This will demonstrate that the main purpose of the communication relates to litigation, and that such litigation is at least reasonably contemplated. Secondly, there is legal advice privilege. This covers confidential communications between your business and your lawyer, made for the purpose of giving or obtaining legal advice, and internal communications recording or discussing the advice for the purpose for which it was given. For legal advice privilege to apply, the definition of client is narrow, so it should not be assumed that anyone within your business comes within it. Care must be taken as to the extent of the group of individuals within your organisation that need to be included in these confidential communications. The investigation team, provided that you can show that there is a need for inclusion in the case of each member, may comprise a safe space that can provide a buffer for privileged material, although each case depends on its own facts. In respect of notes of interviews with witnesses that do not come from the definition of client, be aware that these materials will only be protected by litigation privilege. Care must always be taken not to waive legal privilege and lose the cloak, unless you are advised to do so. Again, this should be the subject of consultation with your lawyers. I hope that you have found this informative. If you do have any further questions or need specific advice, please do get in touch using the details on this page. In the meantime, stay safe and thank you for watching.